Notice the tone here. The defense already signals reluctance, almost like they'd rather skip this whole restitution process. But in court, you don't get to choose your battles. The judge decides what gets heard, and this opening moment sets the stage for tension.
It has set for restitution here.
Okay.
Parties ready to proceed?
Sorry, no, we know where you're going to start.
Well, through the holiday, we didn't want to start at all. But what did you suggest?
Well, Judge, I think for the I'll go with this. Well, we can previously indicated that with the judge recommendation, there's no contradiction report, or just have it. Okay, so the restitution was one issue that's on the hearing on it, and also the recommended 3 days jail time for the bond violation. So that's another point we want to address.
Okay, the bond violation, right? Well, why don't we start with the restitution here? Let's get that out of the way. Try to formulate something that encompasses the whole sentence. And counsel, there was one issue that came up. You see that, and I think copies were sent to the parties because the court had reviewed it.
So, I know, Ms. Morley, you submitted a request today for lost wages as well as reimbursement for therapy costs. So we've already had a conversation about just moving forward with the request on for therapy costs and not lost wages. So we're going to just talk about therapy costs. As far as that goes, my understanding that you receive types of therapy, is that correct? Can you tell me what those two types are?
The first type is for traditional therapy, I guess you would say.
When you say traditional type of therapy, are you saying like psychotherapy?
Oh.
And can you tell me who you see for that? Okay. Do you know about how much you're requesting psychotherapy specifically today?
I believe it was possibly that.
For just psychotherapy?
Oh, yeah.
Okay, so if I told you 145904, does that sound right? Okay. Can you tell me, does insurance cover those appointments for you? Has it always covered those appointments for you in total? Okay. So has your out-of-pocket cost for those changed over time? When immediately following this incident, can you tell me about how long it was before you had your first psychotherapy appointment? Okay, and was it on, have you had appointments ongoing since then, or did you stop?
Quick legal insight. Therapy expenses can be part of restitution, but only if directly tied to the crime. So every appointment, every invoice is about to be scrutinized like evidence in a trial within a trial. Question for you. Should victims automatically get reimbursed for therapy, or does it risk abuse of the system?
Okay. And do you know about how many appointments you've had?
I've done at least all of them.
If I said 22 appointments? Okay. So, talking a little bit about psychotherapy, can you tell me just kind of what that modality is like as far as?
Yeah, I originally started going to that particular kind of therapy before this lesson started telling the hospital with the energy. And after this event, started going to the hospital, and that was really kind of realized something that I loved not to do. That was a mental infection,
But so when I'm asking about modality, is it a movement therapy? Is it a talk therapy? Something? Okay. Is it one-on-one? Is it in person? Okay. And So what makes these appointments after the incident with the defendant in September different from the appointments, if anything?
I've just probably got to make you get a lot of anxiety around this workplace, told them to your health. Want to do that, want to do that. Probably the chance of the fact that this guy is that I might be able to will end it and trying to work through how it got just try to understand how I have something like that.
Hold on. So you were seeing the same therapist prior to September 20th? For how long? Would you like that?
I was just start to.
Go
Has your therapist, Wendy Klinsky, written a letter explaining her treatment related to this incident for you? If you saw that today, would you recognize it? Can you tell me, is there a specific link between those post-September 22nd appointments and the defendant's actions on September 22nd?
Yeah,
In what way?
trying to heal from the trauma of how she acts.
Okay, turning to the second kind of therapy you mentioned at the start. What is that?
That is craniosacral therapy, which I did online.
Please.
I'm sure that happens around October time. I was experiencing and my friend who knows just about it, she hasn't gone back for a because it was even so bad. Sleep, except my conference. Look all these things. I started seeing them to be able to touch the trauma, the event, and the resolving.
Okay. So,
This is where emotion takes center stage. The victim isn't just describing therapy, she's describing survival. Panic attacks, sleepless nights, even fear of human contact. These details aren't just personal, they're ammunition for proving damages in a restitution claim.
you have psychotherapy, which is talk therapy. What type of activities do you engage in this?
I would say the initial part of your process therapy, and then you just one they both on the range, line flat, kind of envisioning the trauma and going to the event without and being able to touch
And you said you did it online. How does that work?
the two things conversation, we just kind of talk about like where I'm at. And they kind of guide me through kind of like a vacation. So I work with the trauma survivors and then trauma that has daily trauma, kind of just talking about like how kind of access my brain and my soul, so it kind of helps me alleviate stress and trauma, way back the top.
So I have that you started craniosacral sessions in February. Is that correct? Okay. And so you've only had 7 sessions. Is that correct? The most recent being in June. And as far as those 7 sessions, did you have any insurance coverage for those sessions? Can you tell me how much your out-of-pocket expense was? Okay. If you saw an invoice for those today, would you recognize it? Your Honor, the people move to admit people's projects was never through.
The objection of what?
I didn't admit the previous ones, did I? Your Honor, the people move to admit those proposed exhibits 1 and 2. Thank you.
Exhibits 1, 2, and 3. Straight away.
Thank you. Clearly under caffeinated.
Yeah.
Can you tell me a little bit about how have these craniosacral sessions helped at all with your PTSD?
Yeah, I will say that I thought this whole yeah, kind of being a pilot is a long shot, but I think it was one of the most helpful modalities that I just tried.
And so, as far as the invoices go, I noticed her address is in North Carolina. Do you happen to know, does she have a license or a certificate or?
Yeah, she has a living hours, so she started out
And what kind of license do you need to do this kind of thing? Do you happen to know?
Okay.
How do we know that she's licensed? And through whom?
Do you know through whom she's licensed?
I don't.
Well, okay, go ahead.
So, just to be clear, in total for the craniosacral sessions, you just had 7 appointments at $90 each. That's a request for $630 for those appointments. And then we previously said $1,459.04 for the psychotherapy appointments. Is that correct? So you're asking for a total of $2,089.04 today? Nothing further at this time, Your Honor.
Mr. Allen, can you
Well, I just have a few questions for you, just to clarify a couple of things. Should not take very long. Again, specifically wanted to ask you about the craniosacral therapy. So this Michelle Tuco, the woman that wrote the letter, so if somebody that your friend recommended, correct? Okay. And you didn't go to your insurance company to see if that's something that would be covered by insurance? She does not accept insurance. Okay, and did you look for her through your insurance? My insurance lets me go on the website and search for professionals to see. Okay, did you find her? The list? Okay. And so this is the virtual sessions, correct? So you understand that Ms. Tuco lives in a different state, right? North Carolina, is that right? Okay. Do you know if she has an office?
Yes.
Well, have you seen it? Have you been there?
I've not known, but I know that.
And you said there was a partner also? Do you know if their business has a website?
There's late last right now.
Okay, so no website.
The next one.
Well, because when I was looking for the Way of Wild Remembrance healing therapies, I was not able to find anything online. So that's why I was curious as to so no website to your knowledge, correct? Okay, and you said it was your understanding that this is licensed, right? But you were not able to find through your insurance, correct? Okay, did you verify her license in any way? Okay, so you just assumed she was licensed?
I don't know.
Okay, but you've never seen any confirmation, never looked into it yourself, correct? Where would you look her up online? Well, I did Google her name, and I only found.
Ruko kazujúca doprava vo. Boom. Cross-examination classic, planting seeds of doubt. The defense lawyer is poking at credibility, because if the therapist isn't licensed, those bills may not count. It's not just about therapy, it's about whether the system recognizes it as valid.
A LinkedIn profile. Are you familiar with it? LinkedIn? Okay. In that file, I mean, there's no picture of an individual, but the only person with that name, says Ann Arbor, is a Thai massage therapist.
Is a what?
Thai massage. Oh, you looked her up on Google? Okay, but you said there's no website.
How do you know they're making one right now? On what?
Were you aware that this is something that I learned while I was preparing for this hearing, that there's a Biodynamic Craniosacral Therapy Association of North America? Okay, well, and so there's a website that lets you look for practitioners who are licensed specifically to perform biodynamic craniosacral. And I was not able to find this to go in Michigan or North Carolina or really anywhere through that website. Is that surprising to you? Okay.
Oh. We may have to get that person up and test it. I don't. Do you know why they're? Well, I'm serious, but I just need something to clarify. Did you read this letter on May 3rd? Did you request this letter from them? Well, because I'm looking at Exhibit 4. You don't have letterhead?
They're not doing that stable.
A letterhead doesn't take wax. It just, well, you know a lot about these people. Why don't you proceed to the question? My question is you're going to go in. It's okay, I'll go out.
All right, and just to clarify, I believe you
You know what?
You testified that you started this craniosacral therapy in February, correct? Okay, so you didn't increase your sessions with your psychotherapist, you just started doing a different type of therapy on your own. Okay, but you were not referred to them through your current therapist, correct? Okay. Well, your psychotherapist letter indicated that you started therapy with them in June of 2020, correct? So you sought out that months prior to the events of September 22nd, correct? Thank you. I don't have any other questions.
How were these bills to the way well remember it's paid? You have the PayPal receipts? You should be able to download them now. So, prosecutor, I want to see that these were paid. Well, I'm still curious. Back up. Great Lakes Psychology Group. You actually go in there. You were seeing them before the 8 of the 6th, right? Before September 22nd. And who was this individual that referred you the way wild? Remember? Who was that? That's my question. Name. Say how she knows the therapist? Somewhat. Conversation you had about them being licensed. Did they say who they were licensed through? I'm not having any payment records. Dates just for like I said, you should be able to get them right now. Counsel, I'm a little bit worried about who these people in North Carolina are. Because I don't know whether it's licensed therapy or anything along those lines. You said your insurance rejected paying for them? What was the insurance basis for rejecting? Pardon? That was their sole reason? That's part of my other concern, Council. Right. Digging on this a little bit. Anyway, and there may be a valid reason for it, but I don't have letter. It should seem unusual of drafting a letter. But also, I noticed that only one of the therapists signed this letter, but I'm worried about the credential of this only because I typically don't receive these on therapy. Not that there has to be, usually have some letters in some type of, or some type of something. And I did nothing at all. And I don't. Well, I have nothing on the letter, and I'm not finding anywhere. I also can see the payment. Looks like payment records from Great Lakes, but I don't see payment that I need if I were to consider awarding the payment records to the other one. I want to clarify one thing. Man, you testified here that they don't accept insurance. So if they don't accept insurance, why'd you secure it? Well, hold on a second. To see if they would cover what? But they had already told you they don't accept it? Okay, so they told you they don't accept insurance. You're telling me you submitted it to your insurance after. I'll ask, what would be the purpose of that?
Sometimes my insurance company threw it out or I don't know, that was it's just all out. So I thought I would try to use it.
Okay, recess. I want to see the one thing I want to see is I want to see these receipts paid out. For continuing. And let me just say that the reason that the records clear, the court counsel information back is because I had received a communication from a China scientist regarding the, I guess, credentials of restitution. And upon receiving them, I didn't quite know what to make of it, so I called counsel back to deal with what the court was supposed to do with the issue. The sum and substance of that is talking about himself again, they just called it the reverse of the order of first. But the sum and substance of that is that there is some...
And here's the legal cliffhanger. The judge questions whether this craniosacral therapy even qualifies as restitution worthy. Think about it. If the provider isn't licensed, is it healing or just expensive meditation? The court has to draw that line.
Accreditation, some licensure, something that makes what Ms. Fuso does, I don't want to use the word rigid, but some type of therapy that the court should consider in this case. There are a few problems that we have entering into that when this analysis coming to the conclusion. I, along with my staff, searched all over to find something regarding this credentials to tie the therapy testified to into therapy that could be related to the offense. I'm trying to say this is the most respectful fashion, but I don't believe that it's this. Let me back up a second. We could find no licensure in the state of Michigan, nor could we find any licensure Stuco in the state of North Carolina where she now resides. And we found, in part, of what was sent to us regarding that therapy and also the testimony of the victim in this case. We found their accreditation and searched for basically three different. First of all, the individual who sent the letter, it's the February 2022 letter, vouching for the credentials of Stuka, search for that individual, and which is basically, we found that individual as being a member of that association. Then search for Ms. Stuko as well as the parents, and neither come up either under the search of North America, or the United States, I should say, or on the search international. They don't come up. Which leads this court, within the emphasis before, to question the credentials to engage or have some therapy related to this case. And I'm worried, well, I'm not sure that this is even the business. I think Tuco's company or assume name, whatever it is. And as for during testimony, proof of payment, I will say that proof of payment was testified to, said it was paid through PayPal. Ultimately, I was provided look like payments, but they're not through PayPal at all. They're cash account. And there are a series of, and so I took those receipts or those payments and matched to the invoices. What's clear to me in this, and I will make the specific finding, is that these invoices, I don't think existed prior to or at the time of the fee. So I say that is because they don't, the payments and the invoices don't match. They're not, some of them are not necessarily all that flows if payment was made when services were rendered. And I'm going to start at the end and come back to the beginning. But I received a June 23rd payment to Ms. Chukro. And there's no invoice. And the court is not going to consider that I don't even have an invoice for the payment. But then when I go through and I'll go back to the beginning, there was a payment made by Ms. Morley of $90 on February 5th. That matches the February 5th invoice. And so that date matches. Go to the next invoice, which was February 8th. Yeah, one ought to pay very close attention to this, because then the invoice says she made it on 19th. Now, I guess theoretically, that kind of thing happened maybe, but the problem with this is that if the invoice is on the 19th, that means Ms. Morley would have made a payment prior to receiving the services. So explain how that happens. And I would note, just parenthetically, that the invoices from Great Lakes Psychology all match when the payment was made. It says when the payment was made. Looks much like those receipts that one received in the box. But going back then to the 18th one, kind of matches, but she would have made it before. There's then a payment made by Ms. Morley on March 3rd. And again, it would have been a payment made prior to the invoice. And the invoice is March 5th. So again, I don't believe that. I don't believe that she paid before that happened, which leads me to some doubt as to these records that are being supplied to the court. I don't mean that by counsel supplying them to the court, but the ones that were presented to counsel give to the court. There is then a March 14th. The March 14th one, I believe, matches, if I'm honest. The March 14th one, there's March 24th, and one page. The March 24th one also does not match, because the payment would have occurred prior to the invoice. Again, then the remainder of those April 1st payment for the June 9th payment. Those match the exact. So the conclusion that the court comes to in terms of looking at those invoices and looking through all of this closely, trying to find Ms. Chukro, trying to see if she has any type of certification for therapy, listening to Ms. Morley testify about how she came in contact with her. I don't think this has anything to do with the events or is directly related in any way whatsoever to the events of the 22nd. I do not, and I will say that the documents in the court regarding this, the quotes, therapy that Ms. Morley received is dubious nature and quality in this court's mind. And the court is not going to award any restitution for those particular items with regard to this Chico. Again, specifically, for the client that is not directly in the the incident trigger for house trigger Chico. Getting then to the let me just before I keep on. Let me just also say that the letter that was sent, the information contained within, I don't think Ms. Duco can make the diagnosis that she's making. I don't know in this. I just don't see how she could with any representation, assuming these two have actually come for her, because I don't letterhead, I don't know anything from what presumably is a therapist association. No, therapy, business involvement. Going to the Great Lakes psychology, I don't at all have the problems that I've had with Chico's business. But the letter that was sent, the May 1st letter, that was sent, and the court's going to quote a specific portion of that letter, which is the second paragraph, and it says, during her September 24th session, Ms. Morley disclosed the assault that had taken place by her employer and further shared the nature of their relationship. The primary focus since the event that occurred has been placed on addressing the trauma that has surrounded the relationship, in addition to addressing symptoms related to
Plot twist. The judge completely tosses the alleged bond violation. What looked like an attempt to intimidate turns out to be a guy returning a credit card. Imagine being accused of harassment just for mailing back an envelope. That's why context matters.
is that the only therapy that was directly related to the event of September 22nd was the therapy that occurred on the 24th of September. Because specifically, Ms. Galinsky clearly indicates that the rest of the time was about the relationship and symptoms related to PTSD from other events and processes, and talks about the concern for her work environment and the impact that it was having on her mental health. Unrelated to those events in this court's mind. Also, so that the record thing, it's very clear the testimony the court has considered it, therapy began prior to this September 27th. So there was therapy with Great Lake on the 13th of September, and then again on the 24th, and then there was therapy after. This letter doesn't indicate to doubt the events or the actions of the defendant as it relates to this charge anytime after the 24th, when the event was relayed to Great Lakes. And so therefore, with reference to that, the restitution request, that court is only going to award the restitution for therapy for that one date. That's the only date, again, it's directly related to the events attending participating. You have no other proof that any time after that anything happened. So In sum and total, for those reasons, the court would bill restitution in the amount of $147.38. Now, with reference to there were really three issues. That's the one issue regarding the restitution, which going to take most of the time. There is then the issue regarding the violation. I was going to take it into account in sentencing, but I think the court needs to make it clear what the court's going to do. And I'm a bit dismayed. I can only just put it that way. Dismayed, maybe a little bit angry. Things I shouldn't say. Mr. Stevens properly admitted to the violation regarding this, as he wrote something on the regarding mail that he had received that he believed should have gone to this mail. It was relayed, and so there, technically, because he wrote that, there was indeed this violation. Ms. Morley, as she related to probation and otherwise, was indicating that Mr. Stevens was trying to sort of tell her what to do, or was making some. The last hearing, the only portion of the envelope we had was the one half of the envelope. Counsel to the defendant had indicated that there was a credit card which was in that envelope. I didn't see the full envelope, so I didn't know, but I know that there was a credit card coming. It was likely going to either be a blank envelope. It was going to see very little about that then is a credit card. When I saw the full envelope, it's very clear that there was a credit card that was finally admitted. Also, very clear that to this court that the defendant wasn't attempting by any means to try to direct Ms. Morley or anyone or anything else along those lines or threaten her in any way. The only thing he was saying is, this is addressed to you, I'm giving it to you, I hope you do the right thing with this. If it had been a company credit card, which I believe that it was, if it was a company credit card, it's his company, quite frankly, should have opened it and said I opened it because I knew it was a company credit card and she wasn't supposed to have it. But that's not what he did. And to be honest with you, I think he attempted to try to do the right thing. What I'm angry about is the representation made to this court, my probation department, and everyone else that he was attempting to make a threat or in some way intimidate Ms. Morley. Absolutely not. That is not what. Everything the defendant represented to the court regarding that envelope, that violation, turned out to be absolutely true the moment I asked for that full envelope. The court could do. So therefore, while the defendant has admitted to that violation or vacated his admission to that violation, I am not sentencing on the violation because while there was a technical violation, I don't believe that that violation was meant to be anything. He was just trying to do the right thing. So I'm setting aside that admission. And I'm doing nothing further with this alleged violation. Mr. Ermolinka, you have said that you have reviewed the report. There are no material deletions, corrections, or additions to that report. Is there anything you or your client would like to say before the court does it?
That's a call investigation.
Sir, is there anything you want to say before I close in? Sent to the court. I'm going to place you on 18 months prosecutor deferred sentence. You're going to pay $555 fine. The court costs $540 probation. Oversight fees, $147.38 is what I said. Restitution payable to Cashmere Morley, payable through the court. When can you pay that? Pay that today. The restitution will be paid in cash to the county. Everything else can be paid in. That's to be paid today. There is to be no use of alcohol, recreational marijuana, or any illegal substance to be subject to random testing as directed by probation. You are to complete a domestic violence program as directed by probation. There is to be no contact with Cashmere Morley, directly or indirectly. There is to be no assault or threatening or intimidating behavior. You are not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. I'll set a review hearing on this matter that is to be held September 16, 2024 at 1 p.m. I will order 93 days in jail. Credit for served, balance suspended.
And there it is, the gavel moment. Instead of jail, the defendant walks with probation, fines, and restitution. But notice, the restitution shrank from thousands to just $147.38. That's the power of evidence, or in this case, the lack of it.